Live from the Glasgow Electric Plant Board, Glasgow Wants to Know. With your host, Mr. Uhel Barrickman.
Welcome to Glasgow Wants to Know. Tonight we're going to be discussing the ethics of the legal profession and the judiciary. You ask, did you say ethics? Yes, I said ethics.
Couldn't pass it up, could you?
There are many, many ethical problems involving both the judiciary and the legal profession. And there are many rules by which the judges and the lawyers have to abide. We're going to discuss some of those rules for the next hour. To do that, we have Judge Benjamin Dickinson, the circuit judge for the 43rd Judicial District, and Judge Ropp of the 43rd Judicial District, who is the district judge. Judge Ropp has served on the Board of Governors of the State Bar Association, which qualifies him to tell you about the organization of the State Bar, something about the rules for the bar and how they're enforced. And Judge Dickinson serves on an advisory committee for this area of Kentucky. Lawyers who have ethical questions can call him and ask for his advice about what they can and what they can't do. And in addition to that, he has served as a member of the Judicial Advisory Commission, Judicial Ethics Committee. We will start with Judge Ropp about the State Bar. It is an integrated bar. Explain what we mean by an integrated bar and how it's organized.
Integrated bar means that if you're going to practice law in Kentucky, you must be a member of the Kentucky Bar Association. It's mandatory. As such, Kentucky Bar Association is an arm, an agency of the state Supreme Court, is charged with at least the management of discipline cases. Discipline cases in Kentucky, and I'm talking about the cases in which a lawyer violates an ethics rule, not where he commits an act of malpractice necessarily. And the area between malpractice and ethics sometimes narrows down, as you well know, awful close. But it starts by filing a complaint with the State Bar Association in Frankfort. It's been reviewed by a tribunal who will issue a complaint if they find that it is not frivolous. It goes from there to a trial commissioner that's appointed by the chair of the House of Delegates that hears evidence which is recorded. That trial commissioner then makes a recommendation to the Board of Governors. The Board of Governors then appoints one of its members to report to the board. Everybody reads it and makes a decision and votes a recommendation to the state Supreme Court, either guilty or not guilty, and then the punishment. And that punishment can run anywhere from a private reprimand to just permanent disbarment. That recommendation, the record goes to the state Supreme Court where the final decision lies. They can do anything they want to at that point. They can either accept it, reject it, change it, or anything. But discipline it takes up a lot of time at the Kentucky Bar Association. And for those who may be skeptic about it, I can assure you that my 2 years there, it is a serious, serious matter. It's taken very seriously, and lawyers do not protect one another. If there is, in fact, an ethical violation. Now, a lot of what you get is, I hired so-and-so to do something for me, and I lost. Well, that's not necessarily an ethics violation. But ethics is important to the lawyers in Kentucky, at least to the organized bar, and we spend a lot of time dealing with it.
You spoke of the Board of Governors, which, of course, is the governing body for the bar. How many are on it, and how are they selected?
I don't think it's changed since I've been gone, but there are 2 elected members from each of the 7 Supreme Court districts, which would be 14. The chairman of the House of Delegates and the vice chairman of the House of Delegates, which would make, 16. The vice president, the president-elect, and the president of the State Bar Association and the immediate past president on there, which would make what, 20 people on there. Oh, excuse me. Also on there is the chairman of Young Lawyers Section too.
Now, the charges that you spoke about, who can initiate a charge against the lawyer, and how is it done?
Well, if you're talking about a formal charge, only the inquiry tribunal can do that as it is now. But anybody can file a complaint, and that's simply done by filing a sworn statement with Bruce Davis, who is the director of the Kentucky State Bar Association, stating, you know, what your complaint is, who the lawyer is, where he lives, he or she lives, what he or she did or did not do that's improper, and it doesn't require that you have a lawyer. And then that goes from if Mr. Davis looks at it, then he refers it out to the tribunal, and they take a look at it to see if it does in fact, sort of like a probable cause hearing. Is there any reason, you know, if they, like I say, if they call up and say, if they send in a complaint that says, well, I hired a lawyer to cut my hair and he did it bad, that's obviously nothing we can handle, but that's where they go from there. Anybody can file a complaint.
The inquiry tribunal more or less acts as a grand jury, if I understand you.
Yes, sir, and it's composed of a former circuit judge, a former circuit judge, a former president of the State Bar Association, and I think a former chairman of the House of Delegates.
I thought the chief appointed one, but maybe he doesn't.
I think the chief, I think, appoints them all, but that's the composition. You know, one of them's, you know, has got to be, and I can't tell you. I think that's still the composition.
Now, there have been some complaints over the years, and I think it's coming to a head, that there are no laymen on the inquiry tribunal, or laymen have nothing to do with filing formal charges or hearing them. Is that correct?
That is correct. Well, they can file the charge. I mean, they can file the complaints, but once they get past that, of course, they're witnesses, and they, you know, and their claims are prosecuted. But they have nothing to do with processing them. Yes, sir, that's correct. They're not in the grand jury type. They don't do any of the fact finding or the punishment setting. That is correct.
Now, are there proposals out there to change that?
Well, sir, I've been gone, as you know, 2 years. We had a 2-day session when I was on the board about that, and the general consensus was that lay folks should not be involved at that stage, because these matters are sometimes very technical about whether or not somebody, sometimes they're not. Sometimes they're just plain old stealing cases, and that's not tough. But if they are, that and the question of publicity are two hotly contested items, and at that time, the Board of Governors voted that they should not be open to the public, and that lay people should not be involved.
I believe that there is a proposed change in the rule to put some lay people, particularly on the inquiry tribunal and possibly on the hearing. And I think they'll be voted on at the upcoming
I think you're
bar
correct
convention
about that.
In Lexington.
But right now there is none. It may change.
Judge Dickinson, suppose you talk about some of the rules that govern lawyers.
Well, let me, if I might, elaborate on one thing that Barlow said. The American Bar Association, at the invitation of the president of the Kentucky Bar Association, came to Kentucky and did a survey, and to determine whether we had a good program for lawyer discipline or a weak program. And they made certain recommendations, and Barlow outlined the two that have received the most publicity is layman involvement and public disclosure of complaints made. I testified before that committee in Frankfurt, and was invited to testify. I did not volunteer. I was asked to come up and testify because I do have some experience in that. And I think that in the difference between what I think and what the bar is recommending, that laymen ought to be involved in it. Laymen are involved in the Judicial Removal and Retirement Commission. They actively participate when a judge is accused of some kind of impropriety, and there are 2 members on that board, 2 lay members on that board who participate and vote on that committee. So I think laymen ought to be involved in the discipline of lawyers also, and I don't think that's a bad idea. I think they can handle that. And the people that we have and have had on the Judicial Retirement and Removal Commission have been excellent folks, and I think we could find excellent folks to serve on a lawyer discipline committee. And the other is publicity of complaints against lawyers. And the debate is, the way it is now, complaints about lawyers are never made public until the Supreme Court makes their decision. And the debate is, should those complaints be made earlier than that? And those of us who think they should be made public earlier think that it ought to be done at the inquiry tribunal stage. The legitimate concern of most lawyers is, don't publicize a complaint about me that's frivolous. And I totally agree with that. But if the inquiry tribunal meets and decides that there is merit to the complaint, then I, for one, and I am in the minority, then I, for one, believe that it ought to be made public. And it's not now. It's not made public until the Supreme Court makes a decision and decides that there's going to be, it's not made public at all if the Supreme Court decides that there was unethical conduct and there will be a private reprimand. Of course, it's not made known then, but if they say there will be a public reprimand or a suspension from the practice of law or a disbarment, then it is published, and that's the only time that it's published. It ought to be published earlier than that.
Mr. Barrett, that, with all due respect to Judge Dickinson, that's not quite correct. It depends on what the charge is, and if the best one I can think of is the Boone gentleman up in Louisville recently who had the trouble with the golfer. If it is a serious matter on which the public might rely to their detriment, the State Bar Association can and often does make a motion to have this person their license suspended immediately, and that's public.
But that's not done. It's not done often. It's rarely done.
I would disagree with you there.
Well, I disagree with you.
Having been there, Judge Dickinson, I know and he doesn't, but that's the only difference.
Another example of where it was done recently was Senator Lamaster.
Yes, sir.
After he was indicted, but before he was convicted, he was suspended.
It's done often.
And there are others that it has occurred recently that I know.
Well, you often named 2 out of several hundred.
But if I understand you correctly, you do agree that there should not be any disclosure until there has been at least a formal charge by the inquiry tribunal.
Sure, just like the rest of the public, that charges against them are not made public until the grand jury indicts in most cases, or until probable cause is found in one way. And that's what the inquiry tribunal is deciding, if there's probable cause. And if the inquiry tribunal decides that about a lawyer, I believe it ought to be made public. It's rarely done, in my opinion.
You have already mentioned the Judicial Removal and Retirement Committee. Elaborate on that.
Well, that's where you make complaints against judges.
I understand.
That's in Lexington and Frankfort. If you want to make a complaint against a judge for unethical conduct, you make it with the Judicial Removal and Retirement Commission, and they decide. Their procedures are different than the bar procedures, and they have an informal type discussion with the judge where you can go and volunteer to discuss whatever complaint is made against you if you want to, and then they decide whether or not formal charges are going to be made against you and whether they're going to hear proof. And if they do, then you're entitled to have your own attorney and present your own evidence, and then they make a decision, which is again referred to the Supreme Court, about whether or not you ought to be removed, suspended, have your pay docked, any number of solutions to the problem.
Can a layman file a charge against a judge?
Yes, you can file it. It's just like what Barlow was talking about private attorneys. You can't make a formal charge against the judge, but you can make a complaint, which the Judicial Removal and Retirement Commission looks into and decides whether there's sufficient evidence there for formal charges to be made. And it's not publicized either until something is finally done in the end, and that wouldn't be bad either. If it's enough that the Judicial Removal and Retirement Commission thinks that formal charges ought to be filed, then I don't see any harm in making it public. And there have been not a whole lot of judges. We don't have that many judges, but there have been several judges removed since I've been around, and that's been 17 years that complaints have been filed and judges have been removed for various misconduct.
And others who have resigned before they had a formal
That's
hearing.
right, and they have the same option. It has to be with the approval of the Supreme Court, but you can resign. But if you do that, then it gets publicized that you resign under charges that would seek to remove you from office.
And I believe, Judge Ropp, that the same is true of lawyers. They can resign with the consent of the Supreme Court, but then the charges are publicized.
Yes, sir.
And published in the
Yes, sir.
advance sheets and the volume of cases.
Yes, sir.
Now, are there many or few complaints and then charges against lawyers?
As a whole, you mean?
Yes.
Okay. I thought you just started on your question there. I guess it depends on your definition of few and many. It's getting more all the time because we have more lawyers all the time.
How many do we have? I forget. How many we do have?
9,000.
About 9,000, approximately 9,000
members
lawyers.
of the Kentucky Bar Association. Of course, you've got lawyers who don't practice law and that kind of thing. It may not be members of Kentucky Bar, but you have about 9,000 or 10,000 members of the Kentucky Bar Association. Probably considering that number, Mr. Barrickman, it's few. And a lot of those, you know, people get mad at their lawyer. I've seen them that say, you know, he didn't treat me right,
Or he lost the case.
there
There are a lot of complaints like that, and
that's
a
why,
whole lot of
you get those kind of things. I don't know what the statistics are. I knew at one time how many complaints end up in charges, but I can't tell you now.
It's well less than half. I know.
It's probably well less than 20%.
But I have noticed over the years, since I've been practicing law, that some years ago, 30 years ago, there were very few. It was seldom that you saw in the advance sheet or in the reporter a disciplinary action against the lawyer.
Yes.
And I have noticed within the last 4 or 5 years that virtually every advance sheet you pick up, and they come out monthly.
Yeah, you ought to tell people what an advance sheet is, because they may not understand that.
But every advance sheet that you pick up usually has anywhere from 3 to 4 to 5 reported cases of where some lawyer has been publicly remanded or suspended and often disbarred. And when I speak of the advance sheets, I'm talking about the opinions of the appellate courts that are published in advance of being put in bound volumes.
Mr. Barrett, let me add to that too. We also have provisions of relatively new vintage in the State Bar Association for arbitration on various items, and I know you and Judge Dickinson both realize, but we get complaints, for example, at the Bar Association that says, I hired lawyers, so they charge me too much. That may not be an ethical violation that needs to go through that. We have fee arbitration, we have legal negligence arbitration, where we try to get people in, and I've sat on both types of panels, where we get people in and say, now, you know, let's see what your fee was. How do you justify it? What were you supposed to do? And it saves things from getting into hassle, and hopefully there's a lot of good feeling over it. But we have that provision that we can do too, both, like I say, legal negligence. Somebody says, well, if it's a big case, of course, you're going to get somebody suing somebody over it. But if it's a relatively smaller case, we can arbitrate those kind of things too. And lay people are the ones who do that. There's no inquiry tribunal. That goes straight to the bar. It's sent out to the members of the House, to the chairman of the House of Delegates, and he sets up a panel. Depending on how much money's involved, it'll either be one lawyer, and there's some guidelines like that lawyer cannot be from the county in which the parties are, so you don't have any buddy-buddy type thing. But that's a valuable aspect of it also. That's sort of a sideline to the ethics part.
And I don't want to open up this can of worms, but I am very much opposed to lawyer advertising, and that's another whole area. But most people don't appreciate the fact that you can shop for a lawyer without, like you can any other professional. You can go into a lawyer, and I'm talking specifically about fee disputes now, and you can go into a lawyer and say, here's my legal problem. Can you tell me how much this would cost, or can you give me a reasonable estimate, or whatever you want to ask them is fair game. And if they tell you something that doesn't jive with what you think it ought to be, you can go ask somebody else and shop around a little bit. But lawyer advertising is not the answer to that problem. I'll guarantee you that. That's not a good idea.
We'll get back to lawyer advertising
some other year.
No, we'll get back during this hour. Before this is over, we'll get back to that, but not at the moment. We've been to, the two of you have referred to fees and possible dispute concerning fees. Is there any rule about how to determine a fee?
Well, let me answer that the best way that I can. If you are a district judge, you have to approve a lot of fees, more so than you do as a circuit judge. And there are guidelines in the rules and in the case law about how much an attorney can charge. They're not concrete. They can't be. They absolutely can't be. Some people might have the opinion, if they had some legal work to be done, for instance, that your opinion might be worth more than mine. As amazing as that may seem, and you could charge more that way. Time spent, expertise, result that you get. All of these things enter into it, and what may be a fair fee for one client and one lawyer in one situation just doesn't apply to the other lawyer. But there, you look at some fees, and some fees that I have disapproved as a judge. I've looked at them and said, it just slaps you in the face. That's too much. But normally it doesn't happen that way. And when I get a complaint about a fee, or I get a motion to approve a fee, I make the lawyer justify it. And if it doesn't strike me as right, I say, tell me how you arrived at that. And they do, 99% of the time, and I say, that's fine, thank you, and move on. Or if a client asks me to do that, do the same thing. And sometimes I don't. But the case is not that usual. I don't see lawyers charging excessive fees in this community. But there again, it doesn't keep you from negotiating up front and getting in writing up front what you're going to do. That protects you and protects the lawyer. But if you don't like what the lawyer told you, ask somebody else, ask another lawyer. But they're just general rules of thumb. How much experience you've had at the practice of law, what kind of result that you had, how much time you spent on it, and so forth and so on. That kind of thing.
But these various elements that you have mentioned about determining a fee are really set forth in a rule, which is 1.5 of the rules of professional, Kentucky Rules of Professional Conduct.
I think there are 7 or 8 subsections to that about naming those kinds of things. I'm not.
And generally there are, as I recall, a total of 8 broad rules that govern the profession, but there are jillions of subsections dealing with various things the lawyer can ethically do and things that he can't ethically do. One of the rules deal with the matter of confidentiality between the attorney and his client. Judge Ropp, you want to expand a bit on that, what that means and what a client can expect?
A client should be able to expect that if he talks to you in anticipation of representation, you cannot be forced later to tell what he told you. Now, if he's talking to you down to Presbyterian Church some Sunday morning and blurts out something, Barrickman, let me tell you this, that may be a different situation. Or if he were to call up your wife Ann and tell her something and she told you that kind of thing. It's got to be in a lawyer-client relationship, expecting representation. Now, if you turn that representation down, as I remember the law, he or she is still protected. But it can't be just idle conversation, but you ought to be able to tell your lawyer everything. Why? Because that's the way he or she's going to represent you best. You've got to be honest with your lawyer, and you got to be forthright with your lawyer if you expect the right kind of representation. And if somebody's afraid that the lawyer will be hauled in by the Commonwealth's attorney and made to tell everything he or she knows, then you're not going to get that kind of rapport between clients. And it goes back, I guess, many, many years as far as I know. And
the rare exception being a client tells you about going to commit a crime. I'm going to commit a crime. You have some duty then to...
You have some duty then. And there are some people who say, you know, that if he comes in and says, I'm going to leave here and go out and kill your law clerk, you have some duty there. But, you know, we got into a case up in Lexington where they called the guy's lawyer in and wanted to know where he got the typewriter, as I remember it. And he was on the way to jail, or thinking that they ruled he could not do that either. Now, you also have the case, very famous case back in, I'm sure you remember better than I do, where a famous Kentucky lawyer went in and spoke to the circuit judge. And the circuit judge is prohibited by law from practicing law, so he could not have expected it. So you got to be careful. If he comes in and will discuss GUI one, he or she may have a problem.
What the story Barlow is telling is the judge said to his friend, the lawyer, I'm sorry that you told me all that. Now I have a legal obligation to tell the grand jury what you just got through telling me. And of course, the gentleman was indicted and sent to the penitentiary. And I'm sure regretted for his lifetime that he had told his friend, the judge, what he told him. But you don't have any legal duty to protect your client from anticipated criminal conduct. From past criminal conduct, you do. That's what he's coming to your office about sometime, is to tell you, I've been charged with this crime, and you've got to know what the facts are. And even though clients charged with crimes very often lie to lawyers, if they tell you the truth and say, yes, indeed, I murdered that person, you can't tell anybody about that.
But again, if they come in and say, well, I intend to do such and such, is that illegal? That would be protected. Mm-hmm. I intend to sell something da-da-da, or I'm intending to dump something that's environmentally unsafe, and you say, no, you can't do it. I still think they're protected at that point.
But it's a hazier area. It's harder. And that's what the whole thing is about, ethical rules. You just can't write them in granite because they don't fit every situation. You've got to have ethical people making the decision, was this fair this time or was it not fair this time? And that's what we try to put people on ethics boards that can make those kind of tough decisions. And they're tough decisions, but they're not that hard, I don't think.
Of course, as I mentioned earlier, there is an ethics board of the State Bar, and you are a member of it, where lawyers, if they have a question of whether they can do something ethically or can't, they can call you or other members of the board. Do you get many calls?
Yes, I do. most of them have to do with conflict situations that they represent a client, and they've got what they perceive to be some kind of conflict situation, and is it okay if I represent this person? And but let me explain to your viewing audience what this is about. We have what you've named is formally called the Ethics Hotline Committee. And myself and 7 or 8 other lawyers and judges around the state in different appellate districts, and I happen to be the one for the 2nd Appellate District, which runs from E-Town to Owensboro. If a lawyer has what he perceives to be an ethical problem, in the past your dilemma has been, do I go ahead and do this and then subject myself to this person filing a grievance against me with the Kentucky Bar Association, or do I turn down the representation just not to take that chance? Well, with that long kind of time delay, that created a real problem for the lawyers. So they created this Ethics Hotline Committee, and a lawyer in the 2nd Appellate District can pick up the phone and call me and say, this is my problem, can I do this? And if I tell him in writing that he can do that, then he's protected, even though I'm wrong. He's protected from anyone ever filing a charge or him ever being disciplined for a charge with the Kentucky Bar Association. And it has to be in writing, and I tell him that. I understand your dilemma. My opinion is this. If you want this in writing, you ask me the question in writing and be as detailed as you can, and I'll send you an answer back in writing, and you're protected as long as that answer holds up. We have kind of, it's just not me interpreting what the judicial ethics opinions are. We have sort of a cross-check between the members of the Hotline Committee that we trade opinions with each other. And if I write an opinion and send it to Rick Underwood up at UK Law School, who is the guru of ethics in Kentucky, if I send it to him and say, here's what I've done, look this over, and if you think there's anything wrong with it, let me know right away. And he's only done that one time in the 7 or 8 years that I've been on this, or ever how long it's been. And he wrote me back one time and said, I disagree with that, and he cited me some authority, and I read that, and I wrote the lawyer back and said, I withdraw the opinion that I gave you before, which he's still protected, but not after I withdraw the opinion. But that's only happened once, and I maybe get, I don't know, 3 or 4 of these a month to answer.
Now you spoke of conflicts. What do you mean by that?
Well, you have a conflict between the interests that you represent. You can't represent both sides of a dispute. And that's easy enough said up front, but there are so many nuances about that it's hard to keep straight sometimes. For instance, the one that is the most obvious, that comes up the most often probably, is representing both sides in a divorce, which you cannot do. And I want to say now that there are plenty of divorces that are granted where only one lawyer was involved, but the lawyer has a responsibility to say to one or the other of the couple, I represent you, I do not represent the other person, and to make it clear to both of them that he is not representing both sides. The other comes up usually with conflicts between government service and private representation. And the most usual instance of that is our prosecutors in the Commonwealth of Kentucky are part-time. They maintain private practices, and very often their public responsibility as a prosecutor comes into conflict with their private responsibility to their clients. And when that happens, their public service comes first. And they have some very close, sometimes, calls to make about that, and you get questions about that pretty often.
If you have a situation where you have members of a firm and one is disqualified from representing a client, what about the rest?
They are disqualified also. One is disqualified, they're all disqualified. And they can't say, Well, I have a conflict here. I can't represent you. Go down the hall and talk to my partner. They can't do that. So what applies one partner applies to all.
Conflicts can arise, of course, in other ways. Suppose you have a client that discharges you, and maybe a year or two later there's somebody else comes along and wants to employ you in a case against him that may involve, maybe only distantly, but may involve some of the issues that were involved in the case in which you represented him. What can you do?
Well, the key word is distantly. If you can't represent one party against a former client if you're representing them about the same matter, if it's a different matter, it's okay. If you represented one client in a I don't know, in a contract dispute, and that client discharged you, and later on someone else hired you to file a suit against that former client about a totally different matter, the conflict doesn't exist because you are not using any confidential information that your former client might have told you to represent this new client in the new matter. If that's true, then you can't represent the new client. If what you learned representing the former client would be to his detriment in representing the new client, then you can't do it. That's what you're avoiding there, is having learned something from the prior client that you're representing the new client that might be a detriment to the prior client. And if that's true, you can't represent the new client.
Suppose you represent a business or a public body, a school, in a harassment case. And then later on you've got somebody and you complete the representation, everything goes
Who are you
fine.
Representing now, the school?
The school, or the employer, as the case may be. Then later on, a year or so, somebody else comes along and wants to employ you to sue them in a different harassment case. Where are you there?
It's much closer, but probably you can do it because it's not the same issues with the same people, but it could be. It very well could be. Because, say for instance, you are representing a company in a sexual harassment case, and you know the company's policies and procedures and what they have done, and you defend them successfully against one claim of sexual harassment by a former employee. And then another employee comes to hire you. Well, you know their weaknesses. And if you know their weaknesses, which was developed by having confidential communications with them, you can't represent the second client. But if it's not anything that you learned during the prior representation that would give you an advantage in the new case, I think you can probably. It's a much closer case.
You have any comment, Judge Ropp?
I just think there's also an area that I read about where you may not be allowed to do it if the old client has an expectation of representation. For example, if you defended the school board for several years, and even though you're not a retainer, they may have an expectation of representation that would prohibit you from taking a new case against them.
That's out there, and that bothers me.
That's right.
Well, being a school board attorney, that would normally bother you.
Or bank client or anything like that. I think there comes a time where, now obviously if it's a one-time client representing a car wreck from representing an insurance company, you probably don't have that kind of problem. But I think there is a line of area where they talk about expectation, particularly where you're offered a plaintiff's case where they don't have an opportunity to contact you first.
Well, what about, for instance, you represent the bank, say for instance, in a foreclosure action against a husband and wife, and then the bank, and you're not on retainer to the bank, and the bank later sues someone else in a foreclosure action, and they come to see you and say, would you defend us in this? And they've got a legitimate defense that it doesn't have anything to do with your knowledge of the bank procedures or anything else. I think you can certainly take that case.
Regardless of the bank's expectation?
That's right, I think so. Because they couldn't expect you not to take that case. If you're not on retainer, I don't think that...
I'm not so sure about that.
Well, I mean, ethics questions are not cut and dried.
That's what I say,
that's right.
and why I said a while ago, that issue right there bothers me.
Well, and that's what makes the Ethics Hotline Committee such a value to the practicing bar, because if you had that conflict and you called me up and said, what do you think about this? And I said, I think so-and-so. And you, in essence, said, would you put it in? And I'd say, well, sure, I'll put it in writing. Then you send me a letter telling me your fact situation, and I write you back, and I say that's okay. And it is okay until I'm proved wrong, but you never can be disciplined as long as you've got a letter from me that says I thought it was okay. And that's a good deal. I mean, that's a good way to handle those kind of situations, because they come up in a hurry sometimes. You come up, say, for instance, the scenario I gave of clients that came into you, want you to represent them to defend a foreclosure action, and they come in to you on the 19th day, and you've got to file an answer by tomorrow, then you've got to know something in a hurry. And that's how valuable that hotline committee thing is.
The thing about the hotline, Mr. Barrickman, I was on the board when he established hotline and suggested they appoint Judge Dickinson.
Did you really?
Yeah,
I got that. Thanks.
Exactly. Anyway, the opposition to it was this: that if you've been around practicing law a long time, like you have, because I've practiced with you, and so has many people call you up and say, Barrickman's
trained a lot of judges.
Yeah.
I mean, yeah.
Barrickman, can I do so-and-so? Barlow, can I do so-and-so? There's where and they don't tell you all the facts. They tell you their side of it, and I agree with Judge Dickinson, most of it's conflicts. Can I do this? And they give you the most elaborate dissertation about what it is. But it is good. I'm not against it, but I say to you that that a lot of times they probably hedge the facts on you.
Yeah, but if you make them put the facts in writing.
They hedge the facts in writing.
Well, I know
they give you
it.
their sides, what I'm trying to say to you. Then all you've got to go on is that. And it's a dangerous, I mean, it can be dangerous to clients, is what it can be.
Sure it can. But if they've cheated you or they've misrepresented to you, then they're caught on their misrepresentation, I think.
But by that time, they've already been halfway through a case, and you know, the hotline is a good thing. It really is. But it's a good thing for lawyers who are legitimately interested. But most of it is somebody wanting to call up Uhel Barrickman, who's practiced law for over 50 years now, and have him say it's okay to do something that they question in their own mind. Mm-hmm. And my opinion is, if they question their own mind, there's probably something fishy about it.
Well, that's a real problem on the hotline committee. And calling up, lawyers calling up with conflict situations that you know stink, and they're calling you up just on the off chance that you might say, go ahead and do that, and then they can go ahead and take the case. I hope that they don't get away with that very often, but that is a weakness of the system.
But this gives us an opportunity to tie some stuff together here that we've been talking about. There is another rule, one of the many rules that govern the bar, is that lawyers have to be truthful, particularly when they're practicing and in their practice. And if they've misrepresented the facts to the person that they're calling on the hotline, then they are subject to being charged and tried for violating the rules of the code.
It's true.
And as I have pointed out here, or have stated, and we can't go over all of these rules, we don't have the time, but the purpose of the rules is to govern the bar, and if the members of the bar violate the rules, then there is a remedy that the bar has and is for the benefit of the public to enforce these rules. And without me elaborating on it, I'll ask the two of you, is there any other profession that has a stricter code of conduct?
Not that I know
than both the legal profession and the judiciary? Of course,
think so.
They go hand in hand.
Not that I know of.
I know other professionals would not agree with that, probably. They would probably say that theirs. But I know what I read, and I know what I see in lawyer discipline, and and what you've observed in the advance sheet is the same thing that I have observed that more and more lawyers are being disciplined and disciplined publicly than many times more than when I came to work here for you, whatever many years ago it was. And a whole lot more cases now, and you just see 2 or 3 or 4, and every time that you read the advance sheet. The same is true for judges. There are not a whole lot of judges disciplined in Kentucky, but there are not a whole lot of judges in Kentucky. There are only about, I think, 225 or something like that. And percentage-wise, there have been several judges who have been disciplined in the state, and I think we have a very active mechanism for being able to file complaints. I don't think we beat around the bush about that. I don't think that we try to discourage people from filing complaints. I do think the system is flawed, and I think it could stand some improvement, but it is a good system. I don't say that.
There ain't any question, that we have the toughest. That was brought up too when we were talking about changing ours, and the question of who does it in public, who does it in private, and most of the professionals do have their discipline in private. The teachers, for example, it's not public, and they're public employees. So it is tough, and it's not a hidden type of situation. I mean, a lot of it becomes public because it's so serious. And a lot of it is not serious. A lot of it's young lawyers who make a mistake. But you always remember the cardinal rule is, as you said a minute ago, if you lie, you're going to have a discipline problem, no matter how big the problem is. I'm talking about if it's money-wise. If you tell an untruth, if you lie about something, in other words, the old thing used to be that if you miss the statute of limitations, you're not going to get disbarred for missing the statute of limitations. But you are when your client calls you and asks you about it, and you say, "Oh, I didn't miss it." Boom, you're not going to get disbarred, maybe, but you're going to get disciplined. And it is tough, and those people who think it's lawyers taking care of one another ought to see the tears run down the cheeks of people who come in before the state bar on a discipline case. I've seen them stand there with tears run down their cheeks. I mean, it's tough.
As a matter of fact, if you read the reports of the disciplinary action that are in the advance sheets in the reporter system, regardless of what all the formal charges may be, there's usually an element of lying.
Yes, sir.
In every one of them.
Some kind of deception, sure.
Some kind of deception in every one of them, and that's what has gotten them in trouble in the first place.
And it should have.
And should have. There's no doubt about that,
You're right.
And should have.
There's the rare case like the man who was involved in the DUI case up in, where was that, in Louisville, Northern Kentucky or somewhere, who got disbarred over that. But that is a rare case. You are absolutely correct.
For driving DUI.
That's right.
Yeah, not that he had represented something.
No. There were 2 deaths involved. Mm-hmm. But the question, that was an interesting case because it was very highly contested. Does that have anything to do with his ability to practice law? The fact that I don't know. I mean, but you're right. Most of it, 90% of it, has to do with lying, stealing, or something in the dishonesty area. And it can be the most minor thing in the world that just something that's stupid lying, and it gets them disbarred. You're right.
Since we're talking about stealing, what are the rules in regard to handling clients' money?
It's got to be put in escrow accounts anymore. That's not true when I first started practicing law, but it does.
Me either.
And let me go back to Judge Dickinson's fee stuff. Today, you must have your contingent fees. And for those who may not know, that's a percentage fee that's usually had in cases like personal injury. They must be in writing anymore. It is unethical not to be in writing. And is that not right? Isn't that the new rule? It must be. That was not true when I started practicing. Also, the fees must be in escrow accounts. And at one time, I think the bar seriously considered making you report your escrow accounts. They do not. That's not in the rules, I don't believe. But it may very well become where they, where you had to report not the names of your clients, but what your escrow account stood at.
Maybe people don't understand.
It's absolutely essential that you take your money, your client's money, and put it in an escrow account, a different account, a trust account, something different from your own money, and you cannot spend it for anything but their benefit. Now, we do have IOTA, which is interest on those trust accounts, But the lawyer does not get a dime of that. That goes for public type activities.
And the lawyer must account for every penny of it.
Every penny.
And cannot commingle. Even if he does it honestly and up front, he can't take that settlement check, put it in his own account, and write his client a check out of his own account, because he's commingled those funds and he can't do it. He has got to have a separate, entirely separate trust account for those funds. And there have been plenty of people, that wasn't the rule. People don't understand that that wasn't the rule 20 years ago, and there were a few, when that rule was changed, that got in trouble because they'd been doing it one way for so many years that depositing those checks of money that was owed to their clients in their own checking account and then writing their client a check, just got them in a mess of trouble in a hurry.
I'm not sure you couldn't take in a personal injury check, write them a check out of your personal account, put it in there. I'm not sure you couldn't do that, but
I don't think you could.
That's dangerous.
I sure wouldn't do that. That's commingling funds.
It's dangerous, but I mean, you're giving them their money right there. I mean, you're commingling their funds when you put it in your trust account, but trust account mainly has to do with money you're going to hold for a while. I mean, if you're going to just get rid of it like that, I think you could. I think it's dangerous to do that. I agree with you.
I don't think you can.
I don't think it's unethical though.
But go ahead and do it if you want to. It's okay.
It's dangerous.
Another problem that arises and has over the years with judges, and a problem for judges, is ex parte contacts.
Terrible.
Explain what we mean by that, and what it is that the public can't do, and what it is that lawyers can't do.
You can't talk to a judge about a pending case that's pending or impending in his court. And that's called an ex parte communication, a one-sided communication. And you can't go into the judge and say, or call the judge on the phone at home and say, Judge, by the way, my daughter-in-law's got a case coming up there, and that her husband has treated her pretty bad, and I hope you do for her what you can. That's an ex parte communication. And it usually comes up like that, or maybe in Judge Ropp's court, a speeding ticket. What can I do about this, Judge? Well, you can pay it, you know, whatever, I don't know. But that, and it's not just the lay public. Lawyers do this too, and it's against the rules too. The dilemma for judges is you can't receive a phone call in your office or at home and somebody says, this is so-and-so, oh, I can't talk to you, and hang up. I mean, you know, they may be talking about the weather or something, and you've just got to wait and see what they want to talk to you about and say, I'm sorry, just wait a minute, that's pending in my court, I can't talk to you about that. And it's sort of like people, it's a bigger dilemma for those few states who are left who elect judges. If you've ever been in a hotly contested judicial race and somebody calls you up and says, Judge, I'm for you and my whole family's for you. Well, thank you very much. By the way, I was driving home the other night from Bowling Green on the Cumberland Parkway and I got this ticket. What can you do about that? Well, you know, I can't do anything about that. And when you have judges who are elected like we do in this state, that's a real dilemma sometimes. And you've got to be very, very careful, because judges should not talk about cases with one side without both sides being present.
Now there are certain restrictions to judges' conduct that aren't applicable to lawyers and lay people, such as political activity and other things. Which one of you cares to comment on that?
Well, basically speaking, you are prohibited. This sounds like a fall. Basically, you are prohibited from partisan political activity. You're certainly, as Judge Dickinson said, we elect judges here, you're certainly not prohibited from political activity, but you are prohibited from partisan political activity, you know. But you can attend these rallies. But you can't get up at the rally and say, I'm a Democrat or I'm a Republican. Those are prohibited matters. You are to, not to, you know, be partial in those, or take sides in any of those. Can't tell people what you are publicly.
Yep.
Can't run on that ticket.
Let me add something to that. That is a recent case that a recent not a judge, but a judicial candidate got disciplined for, and anybody who is a judicial candidate is subject to the Judicial Retirement and Removal Commission sanctions. But the judge, where was he? Northern Kentucky.
Northern Kentucky.
He was, I believe, in Covington. He was running for a district judge, and his advertisement said, I am your pro-life candidate. And they have a very large Catholic population up there, and he was appealing to that. It is a controversial public issue that can come before the courts, and he was sanctioned for that. Should have been. Just like you couldn't come up and say, I'm your gun control candidate, or I'm your right to carry arms candidate, or I'm your abortion candidate.
Can you say I'm your anti-DUI candidate?
No, you cannot.
You're for DUIs, not against them.
Absolutely not. But you can't say, I'm going to be tough. That's saying I'm going to be tough on crime, and you can't say what you're going to do in sentencing defendants until you hear the evidence.
Well,
and you're insinuating that you're going to be hard on them because you have a personal vendetta to carry out against DUI.
I think you've contribute to political campaigns. As a matter of fact,
to partisan political campaigns.
Well, you can contribute to your own, but you can't contribute to John Doe's.
Anybody's.
Well, I'm talking about issue campaigns. You probably could.
You can't, according to the Code of Judicial Ethics, you can't even solicit money for your own church.
That's right. That's true.
But you can't solicit funds for any cause other than your own campaign. You can accept campaign contributions.
You can't ask.
You can't ask.
You got to designate somebody else to ask for
you. You notice I said accept.
Yeah, but this all depends, Mr. Barrickman, as you well know, on your interpretation of the Dan Jack Combs case. Now,
I don't think you ought to rely on that case.
Well, I'm not so sure. If the Combs case is the law in the state, I suggest none of us know what you can do politically and what you can say. But if if the Combs case holds as law, I think I can certainly get up and say, I'm going to be tough on crime.
Well,
that's what you're supposed to do.
If you haven't read the case that Judge Dickinson just referred to about the abortion matter in Northern Kentucky,
I have read it.
I think that case reversed, in essence, they didn't specifically say so, but that case reversed the Dan Jack Combs case.
But you still got a problem with First Amendment speech rights.
I want to tell you what.
That's where advertising comes from, and that's where all these things come from. I'm not arguing with you particularly because I spent 10 years arguing with you, and I usually lost. But when you start bumping up against First Amendment rights, you've got a problem. That's why we have advertisements with guys in gold chains coming up out of Lake Michigan with some woman in their arms saying, call me. I mean, you've seen those. We've been to the Bar Association together. When you start bucking up against my First Amendment rights and start saying just because you're a judge, you can't say so-and-so, I think you're going to have a problem.
I guarantee you, if Dan Jack hadn't been a Supreme Court justice, if he'd have been a little lowly district judge, they would have burned him in 2 minutes. And they did not, because they had a distinct, select panel of plaintiffs' lawyers who were acting as Supreme Court justices. Put that one on film and run that up.
Quickly, Mr. Ropp.
Yes, sir, Mr. Barrickman.
And I know we're about to run out of time. Quickly tell whether or not there are rules about advertising, and if so, briefly, what are
1 minute.
Got 1 minute. There's very little, Mr. Barrickman. And matter of fact, the Kentucky State Bar Association, I was there, learned the hard way because it got in their pocketbook that you have very little control. It has to be truthful, but it certainly does not have to be in good taste.
Does it have to be registered?
No, sir. We have a rule that says you're supposed to send them in.
Okay.
But if you mean registered, if you mean approved, no. They have to be truthful. For example,
but they do have to be sent in or registered with the state bar, don't they?
You are supposed to send a copy in.
Okay.
All right. At least you were some years ago. They may have changed that. But if you're telling the truth, you can do. I'll tell you another thing you can't do. You can't have in-person solicitation.
I was going to ask you about that.
Okay, of things that involve, like, you can't go to a funeral home and say, gee, I'm sorry your grandfather died, I've never seen you before, but can I have the car wrecked? But unless that's an old-time client, but you can do it by mail, you can do it indirectly. You know, we have mass mailings go out all the time. Let me do your bankruptcy case. So everybody's upset the Bar Association with specialization and advertising, and there's probably not a lot you can do about either one of them. Unless it's not truthful. Unless it's not truthful. And then you're hurting in this ethical violation, and they can stop it.
There are many other things we could mention here and discuss, but we've run out of time. I think you gentlemen have enlightened the public about the various rules of both the bench and bar, and we thank you for your time and for your efforts to educate the public on a subject that I think they need more knowledge of, because both the bench and the bar get unjustified criticism because of lack of knowledge of the public as to the rules and regulations that they serve under.
Thank you, Mr. Barrickman. Nice to see you as always.
Thank you, sir. Well, that went faster than I thought it would.
Y'all did well.
Thank you.
Really did. I knew you would.
They'll probably send Dan Jack a copy of that tape.